Good afternoon, everybody. Happy New Year. You're very welcome to the second semester of the Geary Institute for Public Policy Tuesday seminars. Before I introduce today's speaker, a reminder that our question format will take place at the end of the session when our speaker has finished, and they will be addressed to me through the question and answer format. So without further ado, I'm very delighted to welcome Dr. Brian Barry today. He's a law lecturer at the Technological University of Dublin. He's the author of the recently published How Judges Judge: Empirical Insights into Judicial Decision-Making, published recently by Informal Law from Routledge. He examines factors beyond the law that can influence judicial decisions. Brian completed his doctorate at Trinity College Dublin School of Law, and he's also a qualified solicitor. And he's also undertaken visiting scholarships at the University of Toronto and Columbia University. So with regards to our presentation today, Brian is going to focus on research at the intersection of behavioural science and judging. Brian will review the growing body of experimental research studies on practicing judges from multiple jurisdictions, investigating behavioural effects in the courtroom. And at a time when processes governing the Irish judicial system are under heightened scrutiny, Brian will tentatively explore how this and related research could be used to improve how judges are selected and trained in Ireland. So without further ado, Brian, over to you.
Thank you very much, Doran, and thank you for the opportunity indeed. So as Doran explained, my main research interest is in investigating factors beyond law that can affect how judges make decisions. And I'm going to provide an overview of research from my recently published book, How Judges Judge, on how researchers from the field of behavioural science have relatively recently started to investigate judicial decision-making. And I'll take you on a short tour of some of the main studies in this area and explain why this research, I think, is significant for understanding the role of the judge and indeed improving how justice is done in courtrooms. And in that context, I'll reflect on how this research may be particularly useful for the Irish judiciary in light of recent developments. And I am keenly aware of the considerable expertise at this seminar, behavioural economists, policymakers, law professionals, and it is a genuine privilege and a pleasure to be here and to share this research with you. Just to start off, when we think of justice and the edifice of justice, we think maybe of the statue of Lady Justice. And Lady Justice wears a blindfold, and lawyers love this construct that justice is blind and that the law is the law. And she has a sword tucked away at her side, but close by if she needs to wield it. And the statue at Dublin Castle of Lady Justice is rather different. Her scales of justice aren't quite even, and she doesn't seem to be paying much attention to it. She's taken off her blindfold. And Lady Justice here, depicted here, is in fact perhaps a more realistic appraisal of how justice is really done. And judges in their role of deciding legal matters are better represented perhaps by this statue than the last. And they are emotional people. They will have biases, they will make mistakes despite their best efforts. In short, like the rest of us, they are human. And that is what this research is about. And it's about improving justice as well and how it is done. So when we think of the role of the judge, it is something of a balancing act. There is, of course, the law, and then everything else besides. They have to rail against stereotyping and implicit biases. There are influences, political and institutional forces that weigh heavily on their minds. They are, and this will be the present concern, psychological effects in the very act of making decisions that can affect them in their role. And of course, new technologies are an added dynamic to the judicial function. So all of this is at play when we think of the role of the judge. And much research beyond the law has been conducted, empirical research on judicial decision making. And this can be broken down loosely into three strands. Archival research, that is observational research that extrapolates trends and information from judicial decisions, and experimental research, which is a burgeoning field. Controlled experiments where judges or adjudicators are asked to judge hypothetical cases. So real practicing judges dealing with hypothetical cases. And one group of judges gets put in one condition, the other gets put into another condition, and they test various variables that may be affecting their decision making. And then there is, you might say, research straight from the horse's mouth, self-reported research, what judges say about their own role, surveys, interviews, talks that judges give about their own experience. And the concentration here, of course, today will be on behavioral science. And I am quite conscious that the idea of taking the theories from behavioral science and applying them to one area of society or another, on one level is really quite a prosaic suggestion, and one that is commonly suggested in a variety of fields. However, it is undoubtedly illuminating and important in the context of judging in courtrooms, in my view. And judicial decision-making is, of course, a very different type of decision-making from more mundane, everyday contexts. It is far higher stakes. And if phenomena identified by behavioral scientists does pervasively affect the work of judges, and it is the difference between someone going to jail or not, or being awarded tens of thousands in damages or not, then dogged investigation into how heuristics and biases and various other psychological effects affect judges in their role, that becomes something that is very important to know, and crucially important for judges to know about too. So to just very briefly introduce this research, and it is about decision making essentially, and the idea that sometimes we all get it wrong. We think that, for instance, that bread might be the difference between life and death during a pandemic or a snowstorm, and all of us are sometimes good and sometimes bad at making decisions. And behavioral science casts a spotlight on decision making, and like the rest of us, judges sometimes get it wrong because they are, like the rest of us, mere mortals. And of course, when it comes to decision making, and no doubt many on this call will be familiar with the work of these two gentlemen, no two researchers have done more for the field in the last 50 years than Amos Tversky and Daniel Kahneman. And they pioneered and developed research on how people make decisions, and they are famous in particular for developing the field of heuristics. And as many of you will know, heuristics are cognitive shortcuts to make decisions where one relies on intuition, perhaps sometimes over relies on intuitive reasoning. And different thinking, there can be two modes of thinking. We think of system one thinking and system two thinking. And the distinction is as follows. System one thinking is fast, automatic, stereotypic, unconscious thinking, perhaps based on emotion and reacting to a situation at hand. Whereas system two is slower, more deliberative, effortful, more logical, calculating, and conscious thinking. And when we think of judges in their role, we maybe would think that, of course, that judges are always system two thinkers. All that time to think, all that deliberation, all of that paperwork and legal argument to pore over. And predominantly, yes, of course, they are deliberative thinkers, but that doesn't stop system one thinking, the more instinctive type of thinking, from perhaps clouding their judgment on significant factors that may affect judicial decisions. So then we move to how this research has been applied in a judicial context. And these three individuals have done more than any other to ask that question. Jeffrey Richlinsky, Chris Guthrie, and Andrew Wistrich. And to get the ball rolling, they wrote a wonderful paper at the turn of the century, Inside the Judicial Mind, where they experimented on practicing judges attending judicial training days to see if they were susceptible to various cognitive errors. And we'll return to the work of these three researchers in the presentation. So what kinds of heuristics and biases are we talking about? To turn first to confirmation bias. And confirmation bias happens when decision makers selectively choose or seek out information that supports one's preconceptions or beliefs, while perhaps disregarding information that does not go towards that end. In essence, decision makers may overestimate the quality of information that supports their position. So here's an example of a recent study on this in the context of judicial decision making. Researchers from Sweden considered the criminal justice system there, where the same judge made more than one decision or makes more than one decision over the course of a criminal trial process. So, for instance, where a judge makes a decision at the pre-trial stage on, for instance, whether the person should get bail or not, and then that same judge goes on to decide themselves the substantive issue at the main trial. So the researchers ran an experiment to see whether judges' initial pre-trial decisions to detain suspects at the bail application stage triggers a confirmation bias that influences their subsequent assessment of guilt or innocence in the main trial. And 64 judges decided 8 cases inspired by real-life criminal law cases. So these were real judges judging in hypothetical instances, where some of the judges themselves decided to initially detain the defendant, and comparing to those who were told of the outcome at the pretrial stage, this had a profound effect on outcomes. The margin was quite remarkable. Where judges had decided themselves to detain without bail, they were 2.79 times more likely to convict at the main trial than where they were told of the pretrial decision by a colleague that person should have been detained. So comparing the two groups, those who got to make the initial pretrial decision on bail themselves were more likely to convict than when they were told of that outcome. So confirmation bias here, in the sense that their decision on guilt served to confirm their original decision on pretrial detention, seems to be at play, and strongly so. Judges, if you like, double down on their decisions, and they may engage in position hardening behavior in this context. Another example of cognitive error that could be at play is that of hindsight bias. And many of you will have seen this clip before, and unfortunately for the next minute or two, you're going to have to watch it over and over again. And when we see this clip, we know what's going to happen. Hindsight bias can be encapsulated in the phrase, "I knew it all along." And this may be a particularly important dynamic in court cases because of course, judges deal with the benefit of hindsight all the time. If you're assessing the probability that the council's negligence in maintaining the paths during icy conditions here, then the judge is dealing with a past matter with the benefit of hindsight, knowing that the pedestrian has injured himself. And the question is, does this color the judge's judgment? And that judgment is about their appraisal of how likely it was to happen and liability on the part of the council as a consequence. Might hindsight bias affect judges deciding negligence cases? 2 researchers tested for this dynamic on 84 German early career judges, and they prepared a hypothetical case concerning the treatment of a man kept in a closed psychiatric ward. And he had a prolific criminal record and was diagnosed with a personality disorder. In the vignette, it was described how his carers thought he was progressing well. The man entered into a relationship, and his carers decided to allow him to leave to go for a walk with his new partner. Participants in the hindsight condition learned of catastrophic consequences, that the man escaped, didn't return, and was captured 6 months later, at which stage he had robbed 8 people, killed 2, and severely injured 3 others in the process. And participants in the control condition were not told of this outcome. Although knowledge of the outcome should not have any effect on judges' assessment of the perceived foreseeability of a harm occurring, after all we're looking at is whether the carer's decision to release the patient was negligent in the sense that they should have foreseen the danger. Judges with outcome knowledge perceived the catastrophic consequences as significantly more foreseeable than those in the control condition did. More than twice as many judges in the outcome knowledge condition, those who are judging in hindsight, if you like, thought that the carer staff were negligent. More than twice as many thought that they were negligent than the number of judges who were not aware of the outcome. So hindsight bias may be a factor here in differentiating between the groups. That said, there are other similar studies that indicate judges' rather impressive ability to suppress hindsight bias, particularly in criminal law cases. So it is something of a mixed bag in terms of results, and research is at a relatively early stage. Judging by numbers. So aside from what we might classically describe as heuristics and biases, the next category here, and indeed one that is closely related, are effects that can influence judges' numerical reasoning. Judges make numerical judgments all the time. Sometimes they have to convert something qualitative, the culpability of a criminal's conduct or the level of liability and negligence, and they have to convert that into something quantitative, the length of a sentence or the amount of an award of damages. Judges are often presented with guidelines to help with such, sentencing guidelines, or currently, although subject to reform, the Book of Quantum, which gives guidance on what general damages should be awarded for certain types of injury. Judges also engage in numerical reasoning in another way. A judge may be required to consider complex numerical evidence from an expert witness, for instance, about levels of air pollution in a nuisance case taken against a chemical production plant, or pore over the accounts of a company accused of breaches of company law. In these situations, judges must rely on their numeracy skills to interpret the data to make that all-important call on whether the conduct complained of meets or breaches the legal standard. For example, a breach of the duty of care and torts, or whether the accused person commits a crime beyond reasonable doubt. So what can affect judges when they engage in these different types of numerical reasoning? One effect is the anchoring effect. When people make numerical judgments, they commonly rely on an initial value available to them. So when people bid on a house for the first time, their bids will generally be in or around the asking price. And sometimes this can be very helpful to the work of judges. Other times it may have a disproportionate or irrational impact. So are judges susceptible to the anchoring effect? And some studies suggest that they are, and this can have negative consequences. This is a relatively consistent finding across the literature. In one experimental study on US judges, judges in a hypothetical case were presented with an employment discrimination claim in which a boss said to an employee, "Go back to Mexico," an offensive stereotype, after which the employee complained about it. The boss fired her, and she took a case, an employment discrimination case, which was likely to succeed. The question is, what award of damages should be handed down? The judges were put into one of two conditions, a control group or an anchor group. And those in the anchor group were given additional extra information. The complainant employee in the anchor group mentioned that she had seen a reality TV show, a court TV show, kind of like Judge Judy, where a similar complainant in a similar discrimination claim happened to have been awarded $415,300, which is a fairly outlandish amount in this context. Nevertheless, those who heard that information did award significantly higher awards. In fact, about 2/3 higher on average. Now, the average is a little misleading because the distribution of damage awards in both conditions was highly positively skewed, but nevertheless, right the way through the results, the anchor did have a substantial effect. The anchoring effect can work in other intriguing ways. For instance, a relatively recent study, which has yet to be published, concerned handing down a fine or the amount of a fine that should be granted against a nightclub and who had been engaging in noise pollution. Now, the judges received exactly the same information, except that in one group, the nightclub was called Club 58, and in the other group, the nightclub was called Club 11,866, a ridiculous name for a nightclub, but perhaps you can see where this is going. The fines handed down against the nightclub, which was named Club 11,866, were 3 times as much as those handed down against Club 58. So simply the name of the nightclub, an entirely irrelevant number, served as an anchor. Even the role of a dice affected judges' sentencing decisions in a hypothetical case on German judges. In this instance, 52 earlier career judges were asked to find a sentence in a hypothetical shoplifting case. And judges were asked to roll the dice, and whatever number came out was the state prosecutor's recommended sentence. So the prosecutor suggested this sentence to the court. So even though the participants would have appreciated that the resulting sentencing demand was a matter of chance, the roll of a dice, it nevertheless had an invidious bearing on their ultimate sentencing decisions. Unbeknownst to the participants, the dice were loaded to land on higher or lower numbers, thereby creating higher or lower anchors. And judges who were exposed to the high anchor gave higher final sentences than those confronted with a low anchor who gave lower sentences. Judges were susceptible to this anchoring effect by the roll of the dice. Another issue that arises is that of clustering. Now, this is Francis Galton, a Victorian era polymath, and he produced over 340 papers and books in his time. Clustering is to do with the tendency for decision makers to default to specific numerical values rather than perhaps the full range of numerical values available to them. You'll often hear in the news sentences given in 3 months, 6 months, a year, rather than the full spectrum available to them. So this is a matter as well that maybe needs to be considered in the context of numerical decision-making by judges. The other, and this is specific to the legal sphere, the other factor that may be at play is that of when inadmissible evidence nevertheless gets aired in court. So if you try not to think of a white bear, this comes from Dostoevsky's 1863 account of his travels in Western Europe, all you can do is think of that white bear. And inadmissible evidence, does it work in the same way? If we think about what happens at trial, if someone lets slip on the witness stand testimony that shouldn't be heard, that is legally impermissible or inadmissible, then the judge's role and duty is to disregard that evidence. But can they actually do that in their assessment of the case? Wistrich, Guthrie, and Richlinsky tested this in an experiment. In the US, some US states have what's called a rape shield statute in rape trials, which makes certain testimony regarding an alleged victim's prior sexual history as inadmissible at trial. In this case, judges were presented with evidence about an alleged rape. The control group reached a conviction rate of 49% on the evidence presented to them. The experimental group were given extra information. The extra information was as follows. The alleged rape victim's roommate stated in open court that the alleged victim, quote, liked to loosen her inhibitions with a few beers too many and have rough sex with the first guy she saw, end quote. This was inadmissible testimony which the judges ought to ignore. Nevertheless, those who were exposed to this inadmissible evidence, which should have been ignored, convicted just 20% of the time. In other words, it had a suppressing effect on conviction rates. To turn to another dimension, and this perhaps slides ever so slightly, slides or strays slightly beyond the boundaries of studies that could be classically categorized as relating to behavioral science, but what role does emotion play in judicial decision making? Of course, judges simply interpret and apply the law. They are merely an impartial channel or conduit to bring the law to life, are they not? And they shouldn't maybe concern themselves with emotional matters. But of course, emotion, perhaps rightly to some extent, will play a role in the courtroom. We can all think of emotional trials, Oscar Pistorius, Amanda Knox, going further back, the trial of Louise Woodward, O.J. Simpson, all of these high-profile trials draw emotional responses. More recently, in the case of State of Michigan and Lawrence Nassar, where you had the former USA gymnastic national team doctor who was convicted of numerous sexual assaults on children. Judge Rosemary Aquilina speaking to the victims at the end of the sentencing hearing, said, "The monster who took advantage of you is going to wither, much like the scene in The Wizard of Oz, where the water gets poured on the witch and the witch withers away." Now, that may have, of course, been slightly played up for the cameras, but anger may well have been a part of it. And there are any number of accounts of judges who get emotional in the courtroom. How could they not be by some of the material that they pore over every day? So should judges be emotional? Barack Obama suggests that to some extent, at least, there should be empathy. He said that I view that quality of empathy, of understanding and identifying that with people's hopes and struggles, as an essential ingredient of arriving at just decisions, when he was remarking about Supreme Court appointees. And this came in for considerable criticism. So aside from these observations and anecdotes, what evidence is there that emotion perhaps can play a role at trial? In an intriguing study called Heart versus Head, Wistrich, Rachlinsky, and Guthrie asked the following question in essence: do judges interpreting the same law interpret it differently depending on their emotional response to a particular litigant, protagonist? They ran an impressively wide-ranging study entailing 6 experiments on 1,800 judges. I'll give you a flavor of one of those. The case here in one of these experiments concerned the interpretation of a law which stated that the crime was, quote, forging an identification card, end quote. And the question in the scenario was whether pasting a false visa into a genuine foreign passport amounted to forging an identification card. Different judges received information about different protagonists as to why they pasted the false visa into the genuine foreign passport. The bad guy in one of the cases had snuck into the US illegally to kill someone who had stolen drug proceeds from his drug cartel. The good guy in another case was trying to sneak into the US to earn more money to pay for a liver transplant to save his 9-year-old child. The crime was the same, or the allegation of the crime was the same, pasting a false visa into a genuine foreign passport. And whether this amounted to forging an identification card, the same question arose. Nevertheless, the judges favored the good protagonist more often than they favored the bad guy. So, as the researchers observe, without being consciously aware of it, judges' thumbs were on the scale, covertly tipping the balance toward the more likable or sympathetic litigant, so that they consistently prevailed more often than the less likable or sympathetic litigant on seemingly objective and legitimate grounds. Emotion can reach beyond the courtroom, yet infiltrate what goes on within it. These are members of the Louisiana State University Tigers, a college football team based in Louisiana. What has that got to do with judging, you say? 2 researchers from the US National Bureau of Economic Research say quite a lot. They conducted an archival study. They reviewed juvenile court decisions in Louisiana between 1996 and 2012. And specifically, they looked at trends in sentencing of young Black men. They found that if the Louisiana Tigers, a hugely popular team in that area, if the Tigers suffered an unexpected loss, this resulted in young Black men bearing the brunt of longer sentences in the 5-day working week after the game. You got an average 37 days longer in jail, or 7% longer sentence if you were a young Black man facing sentencing after an unexpected loss. There was no impact on young white defendants. So that begs the question, what other external factors may be at play and affect judges' emotions from time to time? Another line of research is starting to look at the relationships within judges' lives. Glynn and Sen tested whether having a judge with a daughter or daughters, made them more pro-plaintiff in gender discrimination claims and women's rights cases. Judges who had daughters were consistently and robustly more likely to rule in favor of plaintiffs in these cases than other judges were. So these are just some of the examples of the studies that are beginning to emerge in recent years and these fascinating factors that may affect judges. Of course, whether it makes things easier or more difficult to understand what factors affect judging is an open question. There are many, many more besides. Attractive litigants tend to fare better in mock jury studies. The order in which judges hear cases can have an effect on outcomes. In a much cited study, Israeli judges appeared to be much more punitive in parole decisions just before they had their lunch when compared to their decisions after they'd had a nice, satisfying sandwich. That study, incidentally, has been called into question. It may simply have been that the order in which different types of cases get heard on the court's lists may have been the difference in the parole applicant's likelihood of success. So they might put the more slam dunk no parole cases just before lunch. That is a suggestion which perhaps calls into question the findings around whether it was to do with the judge's mood. Nevertheless, this burgeoning field is ripe with opportunity to further learn about how to improve how judges judge, and none more so perhaps than in the context of the Irish judiciary. I'm going to focus on 4 live issues where I think this research may be helpful: sentencing guidelines, personal injuries awards and guidelines for awarding damages in that context, and appointments processes and judicial training. So how candidates for judicial office could be properly assessed, and how to integrate some of this research into judges starting out in their training or ongoing training. So 3 of these issues overlap with the work of the recently established Judicial Council. The Council was established in 2019 as a representative body for the judiciary. It is set up to provide training and education to judges to promote high standards of conduct. It facilitates complaints made about members of the judiciary. Within that council are specific committees that are currently reviewing guidelines for sentencing in criminal law cases and guidelines for the appropriate award of damages in personal injuries cases. To turn first to sentencing policy and sentencing guidelines, sentencing, of course, is about setting a punishment that reflects the seriousness of the crime as accurately as possible. And when we're talking about sentencing, we're talking in numbers. This committee, under the auspice of the Judicial Council, comprises 8 judges from all courts and 5 lay members. And its role is to prepare sentencing guidelines for the board. And if and when they are implemented, those guidelines will be monitored. That's in the pipeline. To return to the body of research on numerical reasoning and judicial decision-making, research can inform the development of policy and sentencing. For instance, sentencing guidelines could be tested to see whether maximum sentences or suggested sentences may inappropriately or disproportionately serve as anchors, or if and how the way that numerical values in sentencing are framed. For instance, should a sentence be described in days, months, or years? In the early 1990s, Finnish judges were instructed to sentence theft offenders in days rather than months. And researchers in Finland noticed a drop-off in the average length of sentences. Or perhaps we might look at clustering and how that maybe could be avoided in the way that numerical information is presented to judges with regards to sentencing guidelines. So after these guidelines might be introduced, they ought to be reviewed, compare the previous sentencing regime against the reformed sentencing regime to observe trends and to see if they're having the desired effect. To turn then to personal injuries awards and guidelines for that, some of this research may also be usefully considered in that context. The Judicial Council has established a personal injuries guideline, and it is important to note that in recent times, there have been a number of judges about tempering awards of damages, particularly in the higher courts. And you'll note a judge there, one judge in particular, Ms. Justice Mary Irvine, who is now the president of the High Court and also heads up this personal injuries guideline committee. So to give some background to initiatives in this front, the Personal Injuries Commission published its final report in 2018, and it benchmarked Irish personal injury awards levels against other jurisdictions. It looked at whiplash claims, for instance, and it acknowledged that there were concerns about high levels of damages. The Law Reform Commission recently published a report on capping damages in personal injuries actions, so actual caps on the amount that can be awarded. And it advised that capping damages through legislation would be constitutionally permissible, which is a thorny issue in terms of the independence of the judiciary to make awards as it sees fit. And then the Judicial Council's Personal Injuries Guidelines Committee, comprising 7 judges across all courts, somewhat under the radar in December, presented the first draft of its personal injuries guidelines to the board of the Judicial Council. And these will be guidelines for appropriate general damages for various types of personal injuries, and they will replace the Book of Quantum. And the courts, in addition to being required to have regard to these guidelines, will be required, if they depart from them, to give reasons for doing so. And this is a significant moment for how civil justice is done. Again, to think of the experiments and the research I've described, think about the employment discrimination claim and the TV reality show and the high award in that. That is the kind of research that perhaps ought to inform the development of guidelines and caps in the awards of damages in some contexts. Will these caps, will judges fall into line? Will they anchor towards particular numerical values? Will such interventions, in fact, perhaps paradoxically work against the goals of preventing too high damages amounts? In one study, researchers demonstrated that introducing caps on award of damages actually drew the average awards up towards it. Will judges cluster around default convenient round numbers that come readily to mind? These are matters that I think ought to be tested and thought through. The literature should be considered. The guidelines then should be investigated after they are introduced and reviewed. And all the while, heed should be paid to the behavioural effects and the research that has been identified here. Turning to judicial appointments and judicial training, after the controversy over the disciplinary process regarding Supreme Court Justice Seamus Wolfe's attendance at the Oireachtas Golf Society, which later morphed into a controversy about the process and rigour surrounding his appointment to that court in the first place, the issues of judicial appointments processes is again high on the legislative agenda, alongside the issue of judicial training, which will be undertaken by the Judicial Council. And we really do have an opportunity to improve matters on both fronts. Debate inevitably will turn to who gets to decide who becomes a judge. But as far as I'm concerned, I think is the recruitment process itself. This should entail proper selection criteria, meaningful evaluation of candidates. And this research can, in various guises, aid in that process and in judicial training. In the UK, candidates for the bench are put through their paces. I've spoken to the head of selection policy at the UK Judicial Appointments Commission about this at length. They operate situational judgment exercises to test decision-making skills. Candidates undertake role-playing exercises with actors. Moreover, in many jurisdictions across Europe, early career judges, when they are appointed, engage in rather immersive training. And many of the studies outlined above are just as some of the examples of the kinds of training that they undergo. In Slovenia, a colleague has recently taken this research and run smaller format experiments at judicial training conferences on heuristics and biases to the vast majority of judges in Slovenia. At training days, they're asked effectively to hold a mirror up to themselves, and their errors, often entirely understandable, and their strengths indeed, are revealed to them. So what is the context in Ireland? Well, to generalize somewhat, in Ireland, litigation lawyers become judges, successful litigation lawyers. Now that isn't, there are lawyers in other spheres of the law, but generally it's litigation solicitors and barristers. These litigation lawyers who have made a career out of ferociously fighting on one side of every case they have ever taken must morph into the impartial, blindfold-wearing, even scale wielding judge envisaged by Lady Justice. And the skills required to be a good lawyer and the skills required to be a good judge, of course, overlap to some extent, but by no means entirely. And that transformation from litigator to judge doesn't necessarily happen overnight. And through a combination of more rigorous appointments processes and initial training that reflects on this research and perhaps integrates it to some degree will, I think, improve the lot of judges and ultimately the lot of the litigants who appear before them. would also improve public confidence in a system that has unfortunately taken something of a hit in recent months. But it is important to emphasize that the Irish judiciary enjoys a strong and well-deservedly strong international reputation. A warning before concluding about judicial research generally. In 2016, French tax lawyer and machine learning expert Michel Beneste published data on his website about French asylum judges' decision-making trends. So judges who specialized in asylum seekers' claims. Data highlighted wide discrepancies in the judges' decision-making on whether to grant asylum seekers asylum in France. Some judges rejected asylum seekers' claims nearly 100% of the time, while others, even colleagues in the same court, had remarkably low rejection rates. It was a probative piece of research and one that did not portray some asylum judges in a good light at all. The French Parliament's response was to introduce a remarkably sweeping law, Article 33 of the Justice Reform Act, which makes it a criminal offence to evaluate, analyse, compare, or predict the behaviour of individual judges. It's the first such ban in the world. The maximum sentence for this offence is a quite extraordinary 5 years in prison. The law effectively prohibits scholarship on individual judges within the French judiciary altogether, insofar as individual judges and their decisions must not be identified or analysed. It is a regressive, overbroad, and wholly disproportionate step. It effectively casts judicial scholars as potential criminals. And closing off, academic scrutiny of judiciaries in this way is unwarranted and a disservice to the ideals of transparent, better quality justice. On a far more positive note, there is a window of opportunity in Ireland, and we are well placed for this line of research to play a genuinely useful role. You'll note how the studies that I've recounted don't look at Irish judges. There is some research on Irish judges, particularly in respect of political judicial decision-making. In fact, they have found not to be engaging in political decision-making. Judicial researchers do not set out to admonish judges, nor is their work born out of an inherent mistrust in judges' ability, nor is it a bid to dismantle judicial integrity or independence. The overriding aim is to improve how justice is done. And this research, as I mentioned, allows judges to hold a mirror up to themselves. Judges are engaged, they are collaborating, working towards improving decision-making. And this will undoubtedly lead to better, fairer justice. Thank you.